Good afternoon, everybody. Joining us today for our Islamic estate planning webinar. Thank you for being here. I think folks are starting to trickle in. I just opened the webinar up, so there were some folks in the waiting room who are now starting to enter into today's session. Thank you for being here. Thank you for being patient. We think we've got a good one for you. We'll be starting in just a moment. And a quick reminder that today's webinar is being recorded. All right, I see folks coming through. We are just about 2 minutes from the top of the hour, so in the interest of time, I will kick things off. And again, welcome everyone to today's presentation on Islamic estate planning. Ideally, we're going to have a bit of a discussion, an opportunity to interact with the two subject matter experts that we have assembled for you today. And we'll get to that in just a moment. But first, a quick level set, lay of the land, if you will. Some of you may be asking, what's the purpose of estate planning? What are we doing here? And the short answer is that it's about preserving the assets that you all have spent a lifetime building. So it's about protecting your spouse, children, or other heirs and ensuring that your assets are distributed how and when you want them to be, basically, in accord with Islamic guidelines. So finally, estate management is about managing the amount of estate taxes. Estate planning is about managing those taxes that may be due after your death. There are some fundamental estate management or estate planning principles that can enable you to manage your financial and personal affairs during your lifetime and distribute your wealth after death. We're going to talk about a few of those today with some practical examples. Keep in mind, I will mention that the information and material today is not intended as tax or legal advice. It may not be used for the purposes of avoiding any federal taxes or tax penalties. Please consult a professional for specific information relevant to your individual situation. So with that, let's get through the introductions. Today's speakers are on your screen now. I'm Josh Brockwell. Very quickly, should have mentioned that at the top, Investment Communications Director here at Azad. I'm responsible for all things marketing, as well as our shareholder advocacy programs at Azad Asset Management. Also, going back to the left of your screen is Fatima Iqbal. She's Azad's senior financial planner, has 15 plus years of experience in the investment space. She's also a certified financial planner, and she works with clients on comprehensive wealth management solutions involving things like estate planning, tax planning, charitable giving, and asset allocation strategies. Welcome, Fatima. Thank you for being here. And also joining us remotely today is Abid Awad. He is the founding partner of Awad & Corey, located in the state of New Jersey. And most recently, he has founded Shariawiz, which is an up-and-coming estate planning, will, and trust service for the American Muslim community. It's getting increasingly popular. I'm sure many of us on the call have heard of it. We'll be picking both of our subject matter experts' brains today for insight on this important subject. Welcome to both of you. Thanks.
Thanks, Josh.
A little bit about Azad before we delve into the topic for today. You'll see it on your screen there. Our company was founded back in 1997. Today we manage around $1.5 billion in assets under management for our clients. So we have a long history of halal investment management. We combine that investment management expertise and experience with holistic financial planning, which includes retirement, tax, charitable giving, and estate planning. We'd like our clients to think of us as their personal CFO or chief financial officer, well-versed in Islamic principles. So what I'd like to do now is start things off with a level set, sharing with you a saying from the Prophet Muhammad, peace be upon him, about Islamic inheritance and estate planning. He said, learn the discipline of inheritance, alayhi salatu salam, and teach it. It constitutes half of knowledge, and it's prone to being forgotten. It will be the first discipline to be pulled out from my followers. He encouraged us to learn this, and it's said by many that it is, in fact, half of the knowledge of fiqh or jurisprudence. Furthermore, he warned, alayhi salatu salam, his followers that the knowledge of inheritance is subject to be forgotten, as mentioned there, and at the end of time, it will fade away. So, important reminder for us to see this as a religious obligation, something we should be aware of, something that we should take seriously, and try to preserve it as much as possible. Moving right along. Big question at the top. What is an estate plan? We're here to talk about estate planning. What is it? Simply put, and we'll let our experts get into the details, an estate plan is a map, a roadmap of how you want your personal and your financial affairs to be handled in the case of incapacity or death, and the subsequent implementation of the strategies that will fulfill those objectives. So there are many components to estate planning. We can sometimes get overwhelmed by the particulars. And although we will get into some of these scenarios today, like I mentioned, three big picture scenarios, high level, it's important to remember, again, the big picture. When estate planning is done right, it means peace of mind for you and your family. It can enable you to spell out your healthcare wishes in ways that may help ensure that they're carried out, even if you are unable to communicate. It can help ensure that your possessions go to the heirs that you choose without the endless legal wrangling that can tie up your estate and cause deep divisions in your family. Through effective estate management, estate planning, you can avoid needless expenses and legal costs, and you can provide for loved ones who may not be protected otherwise. These are issues that are too important to trust to luck or to leave to chance. You've got to determine the outcome by planning in advance, and that's why we're here today. I'm going to turn to Fatima now to talk about what happens if and when someone does not have an estate plan. So Fatima, could you enlighten us?
Sure. Thank you so much, Josh. So this is actually a question that a lot of our clients come to us asking is what happens? I don't have an estate plan in place. So what happens to these assets, which I've worked so hard, all my life to build? Now, it's important to understand again what type of property we're talking about, because that may determine again how that property might pass. So if it's property which is owned jointly, then that property is automatically going to pass to the joint owner upon your death. And if it's a type of property that has a beneficiary designation, commonly those are like IRAs, retirement plans, even life insurance, then those funds are going to automatically pass according to your designated beneficiaries when you die. But if you don't have a beneficiary designation or those assets are not owned jointly or have any other owners, then it depends again whether or not you have a will. Now, if you do not also have a will, you don't have anything in place, then in that case, property is going to pass according to your state's laws. Those are called intestacy laws. And those are the laws that govern the disposition of property when someone dies without a will, or again, with a will that doesn't account for a portion of their estate. So again, it's really important to understand, okay, what happens if I don't have anything in place? In that case, again, either the joint owners will automatically receive the property. It'll go to the beneficiary designations if you have it. But if you have nothing in place like that, then it's going to go according to your state's intestacy laws. Now, what does that mean? Intestacy laws actually can vary from state to state. So, again, assuming that, you don't leave any instructions, it doesn't matter what you want. The money is going to go to the person or people that your state's intestacy laws say it should go to. And again, these laws can vary state to state. So if I see here, there's a typical pattern of distribution. Oftentimes it might be, 50% of the property going to a spouse, the other 50% going to children, but, it may or may not be that case depending on your state's laws. So again, the biggest issue here is that your actual wishes are irrelevant. You wanted it to go to according to Islamic inheritance, it doesn't matter. You didn't have a will in place to state that. And again, let's say that you're living in a state that has intestacy laws as patterned on this slide. Now, without an estate plan, regardless of your actual wishes, your assets or your property are not going to be distributed to your Islamic heirs, who again have a right to inherit from you. And again, there could be a lot of different potential problems with this as well. So it could result in disputes among your family. It could result in overall higher taxes. So there is a very simple way to avoid intestacy, and that can be by creating a will. So I would say a will is really the most vital piece of anyone's estate. When people ask me, what's the most basic document that I should have? Everyone should have a will in place, and that even includes adult children. So a will is a legal document that's going to direct how your property will be dispersed when you die. And it also can allow you to name an executor, who's going to be someone who will carry out your wishes that are stated in your will. And of course, people who have minor children, they're often worried about, well, who's going to take care of my children? Your will can also name a guardian for those minor children. And you can also use your will to accomplish other estate planning goals like tax planning. But it's important to know what your state requires in order for your will to be valid. So, to be valid, the will has to be in writing, it needs to be signed by you. Again, the signature often needs to be witnessed, and the number of witnesses can vary from state to state. And all of these end up being very important because again, if you aren't careful, your will could be considered to be invalid. Now, there's one big consideration to having a will for some people, and that's the fact that wills go through a process known as probate. And probate is, again, a court process, and oftentimes that process might go very smoothly. And it could typically last anywhere from a few months to a year, depending on the size of the estate. And as long as the executor does what needs to be done in a timely fashion, oftentimes, those family squabbles can be avoided. But for those families that are concerned about an estate going through probate, again, there are alternative options. So, like I mentioned, for small estates, probate can often, offer the advantage of some court oversight. It might not be very expensive or complex, but for families that or individuals that do have larger and more complex estates, it can be, probate can actually be more burdensome. It can take years sometimes to complete. And that means it could tie up property that your family might need immediately. And also that might mean that there could be additional costs and executor fees, attorney's fees, insurance fees, all that are expended during the probate process. And I'd also mention that if you have real estate in more than one state, sometimes we have clients in that situation, then in that case, the executor has to file in each state where the property is located. And that kind of ancillary probate can again be an additional complexity for your family. Additionally, wills and any other documents that are submitted for probate, they become a part of a public record. So if your family wants to have privacy, or again, you really don't want it to be public knowledge what assets you had after your death, then the probate process won't you help avoid that. And again, if there are issues, and if any of these issues are really a concern to you, then an estate plan can be designed to limit the assets that pass through probate, or even can avoid probate altogether. And that's another process that typically involves using a trust. So now talking about trust, and again, we get a lot of questions, do I need to have a trust? Well, if you're looking to avoid probate, then a trust is a common and versatile estate planning tool that you can use. And in addition, you may also want to use a trust as part of an overall strategy if you're looking to minimize transfer taxes, if you want to have certain property managed by a professional, if you want to leave specific instructions on how to provide for minor children or elderly parents or either other beneficiaries that you might have. And there are also certain trusts that can be created to protect your assets from future creditors. But I would say, again, most importantly, though, trust can provide a means to administer property on an ongoing basis according to your wishes, again, allowing you to maintain a degree of control over that property that is placed in the trust even after your death. So I know, Abid, this is actually an area that you deal with a lot as an estate planning attorney. And I know for us, whenever we're dealing with our clients, really we recognize there's a lot of complexities for Muslims, especially when it comes to their estate plan. Sometimes they'll go to conventional, websites that have, wills and trust templates, but again, they're not conforming to Islamic law. Oftentimes we're finding that people, although they want to follow the Islamic inheritance rules, they're really unsure how to implement them. And of course, we don't have a court system that understands all of that. And I guess, is this something again that you kind of had to deal with again, being an estate planning attorney, and dealing with many clients who are interested in following the Islamic guidelines?
Yeah, let's bring Abid in. I think he's joining us today and was in transit briefly. So want to make sure that he is, in fact, online. He may need a moment. So Fatima, I don't know yeah, he does. So Fatima, I don't know if you have a moment to talk a little bit about maybe some of your own personal experiences with maybe the differences between conventional estate planning and some of the complexities, an anecdote or
Yeah.
two, and then as we wait for Abid, and then we can jump into the three big scenarios to talk about with him.
Yeah, so you were mentioning, again, what are some of the complexities that we've run into with helping clients? I would say, again, sometimes, people will come to us and say, "Oh, I have a will," and when we start reading it, it's a template, right, that they have downloaded from somewhere, they've gotten from their masjid or some other place. And again, some of that language might be relevant, but oftentimes, if it's not reviewed regularly, then it may not be up to date with current laws. And even now there are so many things that are now included typically or should be included in an estate plan. For example, like what to do with virtual assets, right? Or what do you do with your passwords? What do you do with your digital assets?
Right.
Your logins for your bank account or Facebook. So even those templates often are not going to address kind of these new issues that come up. So even if you have a will in place, I would say it's really important to review it, because again, these things can become outdated. So great. I said it's great if you have something, but that doesn't mean that you shouldn't be reviewing it regularly.
Perfect. Thank you. Yeah, and we saw and heard from Abid briefly, just for a moment there. Abid, are you with us now?
Oh yeah, I'm with you. I sincerely apologize about the technical difficulty
No
because
problem.
my trying to get my profile picture up and it's not coming up. So I apologize.
It's all good. We have your voice and we have your expertise, and that's all we need. So I think with that, we'll probably jump over now to the case studies that we were hoping you could lead us through
Yes,
and offer your expertise on.
absolutely.
Perfect. So what I'll do then is basically set the scene, and then we'll have you kind of offer thoughts, considerations as to what the individual in the first case study should do, and Fatima will bring you in as well to see if you have any examples and practical experience in dealing with these scenarios with respect to Azad clients or prospects. So let's take a look at the first individual. We're going to do these three situations where we believe an estate plan is necessary. Of course, as I should stipulate, an estate plan is very personal. You may relate to elements of each of these scenarios, but we're going to put together three roles that present different considerations we think you should be thinking about. So the first is the young adult, Abid, someone in their 20s, probably has some debt, negative net worth, most likely. We're going to call her Sarah. She's a 25-year-old navigating the challenges and complexities of adulthood with student loans, debt, and that negative net worth I mentioned. She's wondering, is estate planning really necessary for me? So, yeah, I guess maybe I'll let you take the wheel, Abid, so to speak.
Yeah, absolutely. Estate planning. The reason we call it estate planning, it's a plan. As the Prophet Muhammad sallallahu alaihi wasallam said, even if you have anything to will, do not sleep one night without putting your will together. An estate plan is covering every aspect of your life during disability or during death at the happening of your passing. So for a young professional starting out with some debt, she may have taken money from her family, from her brother. She has to document that debt in her will. The estate plan is going to include a power of attorney because maybe she's traveling, she's going to school out of state. She's sick. She needs somebody to go handle her affairs, go to the bank, go to Social Security. Maybe she had a car accident. Who's responsible to make the medical decisions for this individual? So when
let me stop you there, Abid. Let me stop you there for a second and ask just to drill down on that, if we could, into the idea of a durable power of attorney. I think that's something a lot of people, it probably goes over their head or they miss it. This is something that Sarah needs in this situation, right? This is a document
absolutely
that it allows someone she trusts to make those decisions on her behalf, including the medical and financial decisions you're talking about.
Absolutely.
Okay.
So you have the durable power of attorney. So an estate plan is a will. It's a living will, healthcare directive, and medical proxy, and a general power of attorney. So the general power of attorney will address issues relating to the financial, and the living will and healthcare directive will address the situation in the event of disability or in the event of an emergency and you're in the hospital. Okay. So these are things that are required so that your family doesn't have to go to courts and have to hire lawyers to make emergent applications in front of the court to obtain authorization relating to these areas. So absolutely, it is handling and organizing your affairs that's important, even if you don't have any money.
So let's talk then about, if we can switch gears a little and go over to beneficiary designations. In our scenario, Sarah has started saving a little bit for retirement. She's got a retirement savings plan. She can determine who inherits her assets directly through the naming of beneficiaries, and that's also an important consideration, right? It's I think, to your point, Fatima, a way to avoid those delays and potential conflicts during that probate process you mentioned before. Fatima, does that sound right? This is an important consideration too. I think some people may be a little concerned that naming beneficiaries, even on a retirement plan, is something that may not comport with Islamic inheritance. Any right. Experience or insight on that?
Right. So actually, when it comes to naming beneficiary designations, specifically on retirement accounts, there are two opinions from the scholars. One is that these retirement plans essentially are part of your Islamic estate and follow the Islamic inheritance distribution. But the second opinion is that these plans are really more like pension plans, and that the distribution should be by document, which is whatever the beneficiary designation is listed as. Now, our Sharia Advisory Board at Azad has adopted this second opinion, which again allows individuals to name beneficiary designations. And as we know, like retirement plans, they have different rules, right? You can't gift your retirement plan to someone during your lifetime. Even how you distribute money from your retirement plan the penalties and taxes can be different based on who inherits that account. So there's a lot of different rules related to beneficiary designations of retirement accounts. But one thing is a lot of people also are not familiar is also there are beneficiary designations even for other types of accounts, like bank accounts or investment accounts. Those can often be called transfer on death designations. Now, for those can be a little bit tricky, because if you are looking to stay in line with the Islamic inheritance distribution, those are set percentages that you name in the transfer on death designation. But if at the time of your death, maybe somebody has predeceased or those heirs have changed, then the transfer on death may not reflect, the Islamic inheritance distribution. So there are some challenges there. But I would say definitely for retirement accounts, it's important to look and see whether you have beneficiary designations assigned to those. And those are like your IRAs, your 401ks.
Okay, perfect. Thank you.
Well, just to follow up on that, on that point is, when you pass away in the United States, your assets are distributed two ways, either by operation of law or by will or trust. So when we say by operation of law, what we're saying is that you already pick a designated beneficiary. If you have a life insurance policy, you have designated a person to be your beneficiary. that passes directly to that beneficiary outside of your trust, outside of your will. If you have a retirement account and you've designated the surviving spouse to be your designated beneficiary, that goes directly to that designated beneficiary outside of what's in your will or in your trust. So there are ways to use these death benefits and designated beneficiaries in ways so that you could avoid probate. But the best way and the cleanest way to avoid probate is having a trust. And we can talk a little bit more because we have other scenarios of couples that really need a trust, and we will flesh that out next.
Well, that's a great segue. So that brings us to our second case study. But thank you. So this is sort of the midlife, mid-career persona, folks who are in their 30s, maybe early 40s, married, just starting a family. So in our scenario, we're going to introduce you to Omar and Nancy. They're a couple in their 30s, starting their family journey. So as they settle into parenthood, they realize it's time to secure their family's future. The first step, some would say, is understanding those core estate planning documents that we've talked about: the will, power of attorney, healthcare proxy. For parents of young children, one of the most important aspects of estate planning, obviously, guardianship. We talked about that. Choosing that guardian is a big decision, or those guardians, plural. And this also, I think, is an opportunity to start talking about setting up a trust for their children's future. Abid, is that accurate, safe to say?
Absolutely. So this situation with guardianship is very, if you do not have guardians set in your will, the only way to appoint a guardian is by court order. So it would require family members to petition with the court to be appointed as guardian. That could take weeks, that could take months. And if it is disputed, like, for example, a dispute between maternal grandparents and paternal grandparents on who's going to be the guardian of their children. So this can turn into quite a nightmare, and a very expensive nightmare for that matter. So having the guardianship resolved in your estate plan avoids all of these uncertainty. And you know better who should be the guardian of your children as opposed to some, third party disengaged judge in some superior court so that's one major thing that most of my clients, once they have children, it becomes more important for them to organize their affairs and pick who's going to be the guardian, and let the guardians know that you choose them in your will.
Right. Excellent. So, Fatima, anything to add here based on your experience as a specialist in estate planning with Azad clients?
Yeah, I mean, I would say that's usually one of the reasons why people think about estate planning is they have children. They say, oh, I want to make sure my children are cared for. A trust, I would say, is kind of like a rule book that you're leaving behind, right? Which can offer trustees instructions on how you want, your affairs dealt with. That can also include, provisions for your children. So, for example, if you know that a particular child may have, some issue which may make it difficult for them to manage large sums of money that they inherit, you can plan for that in a trust. Similarly, children who might have special needs, or even other circumstances. So not only is it just a matter of distributing assets, but also how those assets can be used to continue caring for your family even after you're gone.
And that probably argues, I guess, in favor of the need to revisit the estate plan regularly, right? I mean, I've heard about folks who need to adjust it for changes in life. I guess as life changes, so does the plan. Is that
right?
Yeah.
Of course, estate plans and trusts are living documents, and they evolve with time, depending on changes. You can have, divorces, deaths, remarriages, births. Things change. You may have a designation of one child that does need special needs. In that particular circumstance, a regular trust is not going to be sufficient. So you would have to take into account what we do is we create what's called special needs trust for disabled children, autistic children. And what that does is allows these children to, instead of taking their inheritance, their Sharia share, and making them ineligible for government benefits, we have the Islamic inheritance share go into a trust as a supplement to their income. So therefore, it won't be an asset for that child, and they will be still eligible for government benefits after you pass away, whether it's for Section 8 or Medicaid or what have you. So it's so important that we look at estate planning as our normal planning for our life. And our life always has crises. I consider life a series of crises, and we just learn how to manage them. And an estate plan helps you manage that crisis. What we say all the time at Azad and at Shariawiz is that the objective here is to protect your family, preserve your wealth, and fulfill your faith. So we have this faith framework that we have to build our trust and our wills in accordance with that. And it complies with U.S. law, avoids probate, and you don't have a judge overseeing. I just finished a probate case, 8 years that I've been litigating a case in Kings County in New York. So it can turn into quite a nightmare and expose, the family to counsel fees and family disputes and so forth. So this couple, that's the first thing. You have children, you want to take into account the guardianship, and you want to start transferring your assets into the trust so that everything moves smoothly to your beneficiary without counsel fees and litigation and so forth.
Well said. Thank you. I actually want to break things up a little bit before we jump into the third of our case studies and just kind of maybe rapid fire, do some questions if you're okay with that, Fatima and
Sure.
Abid. And just a reminder to folks that we do have the Q&A option in the Zoom menu. So avail yourselves of that, and we'll obviously try to get to them, if not during the bulk of the presentation day, then at the end, or offline if it's very specific. Some questions just very quickly. One had to do with, and I know, Abid, you're in New Jersey, but you just mentioned you were litigating something in New York. Should we update our trust if we move to a new state? How does that work from state to state?
It generally, your trust is valid where you created it and where you're residing. Now, in the U.S., there's two jurisdictions. There's equitable distribution jurisdictions and there's community property jurisdictions. If you're moving from, say, New York to Texas or from New York to California, a review and a restatement of your trust is a good idea. So what we do is when you establish a trust, that trust, let's say you establish the trust on, January 1st, 1999. Things change. You never cancel that old trust. All you do is you restate it. So when you move, if there are events and changing in your life, it's always advisable to restate your trust to make it governed by the law where you are residing. Now, in irrevocable trust and with high net worth folks, there's differences that you may be selecting a jurisdiction that would be tax advantageous for you. But in most of our cases, those are rare. These are folks with, 20, 30, 40 million, 50 million. They got a lot of money, and there are tax exposures. For folks who are, under the 13 million mark, it's always a good idea to restate to the state where you're living.
Okay, perfect. Thank you. And then there was another question here about what happens to minors without an estate plan. I don't know, it's kind of open-ended.
Well, what happens is that you're going to go litigate. I've been a lawyer for 25 years. I taught Islamic law for 17 years at Rutgers Law School. And I taught New Jersey, New York family law at the law school. and I've litigated these guardianship cases. If you have, so people understand, if you're married, mom and dad, and you're in an intact family, you're not divorced and you're not separated. If one of you passes away, the other party is by operation of law going to be the guardian. But if both of you pass away, who's going to be the guardian? Or if one of you passes away and was the sole custodian of the kid, and you have a father or you have a mother that's not involved, what happens? You got to go to court. And who has legal standing to go to court? It would be either a division of child services, it'll be a relative, it could be a neighbor. So whoever has a relationship with that kid and believes that they want to be their guardian and protect them, they're going to go to court. And that requires a hearing. So you may receive a temporary order of guardianship subject to a trial, and you're talking 6 months, a year, year and a half, and tens of thousands of dollars spent.
Wow.
And could be avoided simply by designating, I want my brother, I want my grandfather, I want my, uncle to be the guardian of this child. So the problem is that people don't realize that this guardianship is complicated. And if you have special needs, that's even more complicated, because if you have a special needs child, even when that child turns the age 18, that child is still a minor. And you still now have to petition the court to get guardianship papers for the adult child.
Wow. So many complexities. Last one before we jump to the third and final case study of it. How do I establish a trust for the benefit of my children and grandchildren is one of the questions.
Very easy. You got two options. You got option one is retain counsel. And you'll sit with, if you come to my office, we'll sit down, discuss your, family tree, your circumstances, your financials. We will decide on what design will serve your family. And we will prepare your trust and help you fund it and prepare the rest of your estate plan. Or you can go, if you're a little sophisticated, you can go to Shariawiz.com and create your trust online with the help of your financial advisor, of course, to give you a little bit of guidance. But that's what you have to do. You either do it online, if you have a complex estate, if you have autistic children, special needs, you have to go to a lawyer to set it all up for you.
Before, I think when we were waiting for you to join, we were talking a little bit about complexities that we see. And I mentioned that, sometimes we see estate planning documents which people have pulled off the internet or have gotten from, a template from their masjid or a friend. Any thoughts on that?
Yes, the issue here, you got to go to a reputable online service. If you're going to do it online, don't take templates from mosques. Those templates, in a lot of circumstances, are not enforceable, because in our community, here's the issue. There's an interplay between the mandate of the Sharia and American law. So, for example, if you put in your will or in your trust, when I pass away, I want my assets to be distributed according to the Hanafi school of the Sharia. Your will is going to be set aside. They're going to apply intestacy laws, and it'll be the secular law that applies. Because surrogate courts and courts in the U.S. are prohibited by the First Amendment of our Constitution and the separation of state and church to entertain or interpret or apply religious law. So the way we deal with it in our private practice, and I have, like I said, 25 years that I've leveraged to create the Shariawiz.com platform. When we do an Islamic will, we put in the Islamic will specifically at the time, if I pass away today, the time that I sign this will, my Islamic heirs are my mom, my dad, my wife, my son, and my daughter. And each of them is going to receive the following share. But if at the time I pass away, something changed in my family tree, I am authorizing exclusively my executor or my trustee to recalculate those Islamic heir shares in accordance with the attached Islamic inheritance manual. This way, we divested the court from the authority to determine what the distribution is. In so doing, our will is now valid, enforceable in a state court anywhere in the country. So you have to take this interplay, and a lot of these masjids, they don't take that into account. And we at Shariawiz and at our office and other attorneys who practice with this specialty do take that into account. Other issues that we see is there is a conflict between state law and Islamic law as it pertains to the distribution and the inheritance shares of a wife. So under the Sharia, a wife is entitled to 1/8 of the estate if the decedent husband has any children, or she will receive a quarter if there are no children. Well, under state law, if you're in a community property state, you're getting half of the property as a community property. In an equitable distribution state, you will have a claim of what's called the elective share, up to 1/3 of the estate. So even in this particular issue, we require, if you want to be Sharia compliant, the spouses will sign either a community property agreement, opting out of the state inheritance law and replacing it with the Islamic inheritance law, or waiving, if you're in an equitable distribution state, waiving your elective share claim in exchange for the share that you're going to receive under Islamic law, under the will or the trust. So there are a lot of these extra elements and issues that you have to take into account if you want your estate plan, whether trust-based or will-based, to be within the parameters. But more importantly, Azad, as a leading Sharia-compliant asset management company, with Shariawiz, we work together, and we have a family waqf structure, which I use in my practice, and it's available on Shariawiz, and most of the Azad financial advisors recommend, is where both parties are able to pool their assets into a joint trust, and it's called Waqf Ahli, and the distribution is triggered to the Islamic heirs after the death of the surviving spouse. In so doing, preserving the marital estate, the marital business, until both parents pass away, and then there's a distribution. So there's a lot of flexibility, because the Sharia is a methodology that produces knowledge. It's the epistemology par excellence of the Muslim civilization. The outcome of this epistemology is called fiqh, which is knowledge. And we live in the United States, and we take into account the circumstances of our living to impact the application of this methodology. And that gave us the family waqf, which has been approved by the Azad Sharia board. And I'm happy to take any questions relating to these items.
Yeah, that's great. And we're going to get to that, and they're coming through fast and furious. Let me just round out these case studies in this segment of the webinar, and we'll get right to it. And it may actually inadvertently lead to answering some of those questions when we do this third and final example here. We're going to talk about the Ali family and legacy estate planning. So the last one, basically folks in their mid 40s to 50s, retiring in 10 to 15 years, caring for parents. So the folks here on your screen, the Ali family, they're in their mid 40s. They're preparing for retirement in 10 to 15 years. They're part of that sandwich generation. A lot of us are balancing care for their children and aging parents. Let's talk about those core estate planning documents first. Wills, trusts, powers of attorney, and healthcare proxies, right? So obviously, all those things we talked about before, bodies are going to need to draft a will that specifies their wishes regarding asset distribution, trust that can provide for their children's needs while ensuring that efficient asset transfer we've been talking about. They also want to consider if their parents need financial support in their estate plans. So ensuring that their parents have effective estate planning documents is crucial for that family's security. So in addition to those things that we've kind of talked about, and obviously there are specifics related to everybody's unique situation, there are tax planning strategies here. Fatima, I don't know if you want to mention, we can talk about ways to minimize liabilities, maximize wealth. If you want to look at the lifetime wealth transfer, that sort of thing. Gifting strategies. Those are things obviously you specialize in. I'm sure you have a lot of experience with as well, correct?
Yeah. So
Yeah.
on tax planning issues, you gotta take into account from a federal law perspective, you know, each spouse is entitled to almost $13 million is federal estate tax deduction, which means you're not going to pay 40% estate tax if your assets are under 13 million. And if you are married, you can combine the 13 to 26 million. So it's very few people in the country are going to be subject to the federal estate tax. However, there are inheritance taxes and there are state taxes on state level. So for example, if you're in New York, there's a serious estate tax issue. In New York, and everybody knows that if you own a home in New York, it's probably going to be worth $2-3 million. Their estate tax triggers at $6 million. And they don't allow portability of a $6 million, meaning $6 million for wife, $6 million for husband. So if your assets at the time of your death are $6 million, you're paying hundreds of thousands in estate tax in New York. So we have tax planning strategies, and we create certain types of trusts, what we call bypass trust and credit shelter trust, to make sure that at the time of your passing, you're under that $6 million in New York to avoid it. In Massachusetts, the estate tax is at $2 million. That's very low. If you look at states like in Pennsylvania, there's an inheritance tax up to 4.5%. And there's strategies that you have to take into account to minimize it. Also, in our community, we have a huge issue where I had a client just last week. He came to me, say, I heard your lecture at the mosque, and I don't want to die and not have all my affairs in order. I have 3 homes, $2 million each, but 2 of them are for my brothers, not for me, but I put it in my name because, my credit is good. And so, but I don't want to die and then something happens to the house. I want the house to go to my brothers. No problem, sir. Your brother's going to pay 15% inheritance tax in New Jersey because in New Jersey, Class C and Class D, specifically siblings, are going to pay up to 15% inheritance tax. So there's a lot of minefields that are unique to our community because most of us put property in dad's name and uncle's name, brother's name, and these things, when they come and they're going to go to a court through probate, under probate administration and court supervision, all of these tax issues are going to be exposed. So we definitely take into account advising our clients to manage these minefields. But again, if your assets are under 5 million, not complicated, you're a W-2 wage earner, you can save. We charge anywhere from $3,500 to $5,000 per trust. You can go on Shariawiz and you can make it for $4.99 or $7.99 with the help of your financial advisor. So it all depends on your assets and what kind of advice that you really need.
With that, we are going to jump into the questions, and we've already kind of done that informally. And so, Fatima, I do want to bring you in here, and we got a question about, and Abid, obviously you can jump in as well. A person who has a revocable living trust, wondering if they still need a will, and vice versa. Can you comment?
Yeah, I mean, typically, go ahead.
I can address that. That's a very simple question. Keep in mind is that there are certain things that you cannot put in a trust. Guardianship of the children has to be in a will. Your burial and autopsy issues have to be in your will. But number 2, when you have a living revocable trust, you have what we call a pour-over will. And the purpose is because if you pass away and you did not transfer certain assets into the trust, those assets that were not transferred to the trust are going to go through probate. And the will, the pour-over will advise the court, by the way, judge, on such and such date, I created my living irrevocable trust. If there is any property that's going to make it to my estate and be before your jurisdiction and authority, Your Honor, I want you to transfer those, direct the estate to put them back into my trust and to be distributed according to the terms and conditions that are contained in my trust. So that pour-over will is kind of like a catch-all. It's a safety valve in the event that you miss something in your funding.
Okay. And
Yeah, and I just
go ahead.
sorry, and Abid, I thought maybe another thing that you can maybe you can address. Sometimes people they create the trust, but they never fund them, right? Or they have like a list of assets of like, oh, these are the assets that should go into my trust. What would you recommend? Do you recommend people fund their trust by retitling assets? Is it okay just to leave a list, with in the trust document with assets that should go into the trust? What do you generally advise your
Yeah,
clients?
it defeats the whole purpose of the trust if you do not fund it and you don't retitle. So the whole objective is to avoid probate, keep your affairs private, keep the court out of your family, and make things smooth transition for your family. Keep in mind, if you have a will, once you pass away, all your assets are frozen. Even though you have appointed an executor, you have to go file the will. You got to find the original will, and you got to file a petition and get the court to issue orders that appoint the executor so that executor can act as your account. This can take weeks, it could take months. And imagine, in the middle of grieving, you have to be worried about getting court documents. In the trust, because all of the assets have been funded, there's no need to go to court. The trustee takes over instantly. Access to bank accounts, access to your financial accounts, everything seamlessly, immediately upon your demise or incapacity. So if you don't fund, then we got to go to court. So you got to retitle your real estate. You got to retitle, and it's very simple. Whether you hire a lawyer, we take care of all of your funding. If you do it online, if you go to Shariawiz, we have a detailed funding guide, and we just signed an agreement with udeed.com for $300. They will transfer your deed and take care of everything related to transferring your home from your individual name to the trust name. Now, of course, we don't recommend retitling retirement accounts, because retirement accounts are tax deferred accounts, and retitling them will have taxable implications. So you can update your designated beneficiary, as Sister Fatima already said, and apply the beneficiary to your list of Islamic heirs, or, depending on your position on the Sharia, it could be that, the wife is the surviving spouse to take the entire retirement shares. It all depends on your level of compliance of which school that you want to take. For example, in Saudi Arabia, in Egypt, in many Arab countries, the issue of a pension and retirement has been not viewed as inheritance, but rather considered that it goes directly to the immediate family who needs the support. So you have that flexibility to work around it.
Since you mentioned, retirement plans in other countries, any thoughts when it comes to overseas assets? Again, we often have clients who have property overseas. Maybe they inherited it or they purchased it. Does their estate plan include those assets then?
No, unfortunately, an American trust cannot own assets in other countries because those other countries won't allow. Now, if you have assets in Pakistan or in Egypt or in Palestine, generally what I advise my clients, you only have two options. Option one, those assets are going to be distributed according to the Sharia when you pass away. If you want to avoid the nightmare of the Sharia court and the headaches of trying to, rummage through these issues and you're not living there, I advise most of my clients to go to their mother country and retitle the assets to their children in their lifetime. Because otherwise their children, I mean, look, we're becoming second and third generation Muslim Americans. Many of us don't go to their mother country or even know the language. So in your lifetime, you know the country, you're from Pakistan, you know the lawyers, you know the people. You go back there, you retitle everything in your kid's name. You just avoided a nightmare for your children, because otherwise they have to do powers of attorney or they have to travel there to deal with it. So I highly recommend retitling the property or selling the property and putting it in a Sharia-compliant investment fund at Azad and preserve that for your family.
Thank you. Also, a quick toss up just for whoever wants to take it. There was a question about the difference or preference when it comes to a revocable versus an irrevocable trust, when it's a good idea to have one versus the other. Does it depend on net worth, or and also can you explain the differences between the two?
Yeah, I get this question all the time. A lot of our I had this member of our community called me up, and he said, "I want an irrevocable trust. I've been reading about it." I'm like, "Okay, well, what do you have?" "Oh, I have this business, and I think I'm going to be sued, so I want an irrevocable trust, for asset protection." So I explained to him, "You understand, when you're going to do an irrevocable trust, you cannot be the beneficiary of that irrevocable trust, and you lose absolute possession and control of that asset." So people who do irrevocable trust are generally in two categories. People that are ultra wealthy, and we are doing it to avoid the estate tax. So I'm working on here's one point before I forget, this is off topic. Life insurance proceeds are considered part of your estate value for purposes of the federal estate tax. What that means, I have a client now that has close to $9 million in life insurance. That $9 million plus his assets puts him over the federal estate tax exemption. So he's subject to a large 40% estate tax. So what we do is we do what's called ILIT. This is a irrevocable life insurance trust. So we transfer the trust into an irrevocable trust, put money in the irrevocable trust to pay it directly, so that it is not part of our estate, that I have no control over it and I don't own it. So we do irrevocable trust to take things out of your estate so that it becomes a dynasty trust of some sort that will continue for your children. So irrevocable has either high net worth, or in the smaller time, I don't do this type of work. It's called Medicaid planning. So let's say you only own a home. This is all your life savings. It's worth $700,000. You're afraid that you're going to get ill and go to a nursing home or medical bills, and they're going to take your home away. So we would do Medicaid planning by creating an irrevocable trust, put the house in the irrevocable trust. No longer it's your asset, so the government can't take it. But the government has a 5-year clawback to go back 5 years to make sure if you transferred it within 5 years, they will cancel the transfer and you'll still be responsible for those medical bills. So irrevocable comes into play in very limited circumstances, and it's only for a few percentages of our community. Live in irrevocable, you control it, it's yours. But when you pass away, a living revocable trust becomes irrevocable, and it's got to be distributed according to the terms and conditions. Now, we also have clients, we can start out with a living revocable, and when both mom and dad pass away, we can turn that trust into an irrevocable dynasty trust. I just did one for a client. Client owns a gas station, and he owns the land that's on the gas station. That land is worth like $5 million. So what we did is we structured the two separate entities. One entity owns the land, and then the gas station is a business that's owned. The gas station entered into a long-term lease with the land, and they pay $300,000 a year in rent. So we put, when he passes away, both parents pass away, the trust will become irrevocable, and the children will receive that rent indefinitely. The children and the children's children. So yes, there are circumstances where an irrevocable can come into play, even if you're not high net worth, if you wanted to create a trust fund for your children.
Very nice. So that's, I mean, I could listen to you all day, honestly. I mean, I'm taking a lot of this in, learning a lot myself. I do want to get to some of the other questions we have here, and there are quite a few. And if folks need to drop off since we're at the top of the hour, we understand that. A recording will be provided shortly after the completion of the webinar. We just needed a little time to get it on the site and sent out to you. So that was one of the questions we got as well. So yes, in short, there will be a recording available. I did want to ask as well a question about the where's this coming from? What are your sources? What are your Islamic ruling sources on these issues? Folks who are Sharia sensitive and religiously conscious, they want to know that this isn't just being made up, right? So can one or both of you talk a little bit about the rulings and the Islamic sources for putting a will or trust together?
I mean, I could address, and Fatima, she's an expert on Islamic law, but you understand, if you pass away in the United States, if you don't have an Islamic will, you're governed by intestacy laws. In New Jersey, if you pass away, you're married and you have kids, and you don't have kids from any other partner, 100% of your assets go to your wife, period. Your parents don't inherit, your children don't inherit. So when you want to talk about authority for an Islamic will, every scholar in the United States and every imam tells you it's an obligation to have an Islamic will or an Islamic trust in the United States, because otherwise you're not applying the Sharia in the distribution of your assets. Now, that's the big picture. That's the overarching obligatory fard that the scholars have concluded. Now, the nature of the distribution and the nature of the trust and how you formulate it, there can be differing opinions. There's one opinion that says when you pass away, your assets must be distributed, period. That's one school. There's another school that says, yes, we understand, but if you create a waqf in your lifetime, that's not inheritance. And you can have a waqf that terminates at the triggering of an event. You made that decision in your lifetime. You transferred those assets in your lifetime. It's not inheritance. So that's the authority for the joint trust that's structured as a family waqf. So you have these two opposing opinions, and their opposing opinions, the Sharia, the scholars were asked, how do you define fiqh? What's the definition of fiqh, scholar? They define it as ilm al-ikhtilaf, the science of difference. Fiqh is diverse. So you rely on your scholar that you trust and follow his opinion. There are scholars that agree that a family waqf, suspending distribution until the triggering of both passing away, our Sharia board at Azad said that's Sharia compliant. You're going to find some other scholar that says it's not Sharia compliant. So you should apply whichever opinion that you feel closest to your religious beliefs, because there is this diversity. Now, other than when it comes to the percentages, those percentages are in Surah An-Nisa. That's pretty standard. The authority is the Quran. With respect to other aspects, such as, like, we provide life estate to your wife. There's discussion about that in the scholarly books, but that is our authority. The authority is the Quran and the scholars. But that's really the big issue: the trust terminating at your death or terminating at the survivor's death. That's the only kind of fiqh issue that I can see.
Yeah, and actually there was a few questions that came in also somewhat related to this, like for example, what if you have circumstances where a surviving spouse is financially responsible for the family, and in some situations maybe a wife is only getting 1/8 of an inheritance or a husband's only getting 1/4. But again, they're responsible for the finances of the family. And that's really where like these other solutions are available. Of course, there's lifetime gifting. There is waqf al-ahli, as Abid mentioned. So again, the Sharia also has some flexibility in addressing certain needs, but it's important again that when we create the framework, we're not just saying, oh, we're just doing whatever we need to do, and we don't have an option. I think, again, alhamdulillah, over the years, we've been able to find solutions that again stick within the Islamic guidelines, but also meet the various needs that families have. And again, families are changing. Again, situations can change over time. So it's always important to review this.
Mm-hmm. I'm gonna just say one story for the audience to understand the level of the sophistication of the Sharia system and the level of the just and fairness anchor of the Quran and of our founding fathers of our religious tradition. There was a situation where it was a couple in Mecca. The wife was a famous dressmaker, and she would stay up all night making these dresses, these athwab. Her husband would take them in the morning and he would go and sell them in the market. They made a lot of money. He passed away. When he passed away, according strictly to the Sharia, 3/4 would go to the paternal line, and she would get 1/4 because there are no children. She went to Amir al-Mu'mineen Umar ibn al-Khattab. We call him the Just al-Faruq because of the level of his just determination. And she told him, you know who I am. I'm that dressmaker, Amir al-Mu'mineen. They're saying they want to take, they only want to give me 1/4. He says, sister, you're the one who worked with your husband. Half of it is yours already, and you get your 1/4. He flipped the formula because when a wife contributes, works at the business, manages the finances, leaves her career to raise her children, she's making financial and non-financial contributions to the acquisition of the marital estate. Under the Sharia, she has created a legal and equitable claim. And that's what the scholars in the Maliki school created, a cause of action, a claim called al-kad wa si'ayah, work and effort. And they said if a wife contributed to the acquisition, she has a claim. Why are we looking at the Sharia as this methodology that produces justice? That if a spouse, and I have a daughter, if my daughter leaves her career and joins her husband and raises the kids and does everything, she just left a promising career. Is that not a contribution to the acquisition of the marital estate? Should she not get some credit for those sacrifices? And the Sharia allows it. So yes, there are these Sharia solutions that we have in our private practice and on the Shariawiz platform where we acknowledge these contributions. Therefore, you will receive those contributions plus you receive your 1/8. We are not changing the Sharia portion. Absolutely not. That's set forth in the Quran. But what we are taking into account is the acquisition of this marital estate. How was it acquired? And do I have a claim to it other than my claim for inheritance? And that's why it's dealt with as a debt. So the kedwa si'aya and these causes of action are considered debts on the estate that have to be paid from the gross, and then the Islamic heirs take their percentages.
There's a question that came in, and I've heard this before. Is again, if I want my will or my trust to distribute according to the Islamic inheritance percentages, Can a state challenge that, especially like community property states?
It's not the state that would challenge it. The state's obligation is to implement the testator's wishes. Who would challenge it will be the beneficiary. So if you write your will and your wife is to receive 1/8, if your wife is content with the 1/8, she's not going to contest the will. And if she does not contest the will, therefore, she will receive her 1/8 and the court will enforce that will. So that's who's going to, somebody has to contest it. Now, the only way where the state won't enforce is if the will is not properly drafted. And it basically says, hey, judge in California, I want you to apply the Sharia to the distribution of my assets. Well, what does the judge know about the Sharia? That's a religious moral system that he has to apply, which would violate the Constitution, and he can't do it. So yes, in that particular limited circumstance, the court won't recognize or enforce the Islamic will because legally he's not or she's not able to do it because it violates the law. The other circumstances, the beneficiaries are disputed.
Yeah.
Hey, Abed, you're sparking a lot of questions in the minds of our attendees, which is great, and some of them are very specific. Some of them are broad. I think it probably does make sense to get in a quick plug here for Shariawiz. There are questions ranging from, does Shariawiz work for all states, or is it specifically in like the New Jersey, New York area? And also a question about whether or not if someone uses Shariawiz for estate planning and they need attorney's help, is that also available as an added service? Can you answer both those, please?
Yeah. First, Shariawiz is available in 49 states. The only state that we're not available is Louisiana. We offer estate plans that are will-based, individual trusts, or joint trust, and we also include Islamic prenups. So we're doing Sharia-compliant prenuptial agreements as well. You can do, we have customer service, we help people. Shariawiz is not a law firm, so it can't give you legal advice, but we have a lot of customer service and help you through the process if you have any questions. If you need a lawyer, depending on what your state you're in, I practice in New York and New Jersey, but I also have a network of lawyers nationally, so I co-counsel a lot of cases around the country. So we can definitely represent you as lawyers if you need to. I always prefer a lawyer, but if it's not that sophisticated, save your money. I'd like to take your money, but you may be able to save yourself $4,000. It may not be necessary. And you may need a lawyer later. Like you can start out with a family waqf right now, and your assets are like 3-4 million, but all of a sudden now you're a very successful position and something changes. You can always update your documents with a lawyer.
Speaking of updates or specific situations, maybe this is dependent on the state too, but someone asked about a trust that they have where real estate assets are listed in an attachment to the trust. They wanted to know if that was enough or if they have to re-record the properties in the name of that trust. Could you comment?
No, that's not enough. They need to retitle those properties into the name of the trust. So either he goes to a lawyer to transfer those assets to the trust. If the properties are in LLCs, if they're titled in LLCs, it's very easy to transfer them to the trust. All you need to do is do an assignment of your membership interest into the trust. If they are titled in individual names, you can go to a lawyer or you can go to ud.com. We just signed a contract with UD to make it easier for our customers at Shariawiz. The letter U, DDEED.com. They charge about $300 plus filing fees to do the transfer for you. But you need to fund your trust. Otherwise, those real estate properties are going to go to the court.
Perfect.
Josh, I see an interesting question that's come up again, which we get a lot, which is, I've set up my estate plan, or basically I own everything jointly with my spouse,
Yeah.
and my spouse knows what they want, what I want everything to go according to the Islamic inheritance distribution. Does that work? And I've even seen situations where they've left it maybe to the eldest child, saying, okay, I'm leaving everything to my eldest child. They know what I want, and they'll do the distribution. Um, I know there are concerns around that, but would love to hear your thoughts, how you counsel
Oh, of course,
clients.
that's a nightmare, because if you're giving everything to your son, sure, your son, you're class A in New Jersey, for example, so you will have no inheritance tax. But now you're taking money and you're going to give it to your siblings. So now there's going to be gift tax issues that you need to take into account. It's always better, even if you own jointly, you have two options. Option one is when you own things with your wife jointly, if there's a right of survivorship, by operation of law, that marital residence you live in is going to go to your surviving spouse. Doesn't matter what your trust says, doesn't matter what your will says. If you want half of it to go to your heirs and half of it to stay for your wife, you have to change the deed and remove the right of survivorship from that deed in your property. That's why when you do a family waqf, all these issues become resolved, and you don't even have to deal with them. Because now what happens is you have a surviving spouse taking over the trust management, which is all the assets that both of you own. And then the distribution is going to take place when the survivor passes away. So you have to fund your trust. There's no way around it. If you jointly own it, either you remove the right of survivorship, or the survivor is going to get the property.
And can we just clarify very quickly? We've thrown out some terms here, and I feel like maybe we're using them interchangeably. When we talk about a family waqf, what is that? How does that differ from a regular trust, or is it revocable? Is it irrevocable? Can we just kind of maybe define some
Yeah.
terms? I know we're a little late in the game.
So here's the situation. A waqf is a trust. The whole concept of the trust in the common law originates from the Islamic law of waqf. When you look, Professor John Maqdisi, a really prominent legal historian, wrote this seminal article like 20 plus years ago called The Islamic Origins of the Common Law. It was clear that in the world, there are two legal systems. There's the common law system and the French system. In the civil law system, they never developed the concept of trust. The trust was developed in the common law system, in the British system. Well, how did that enter into their system? It entered their system in the 10th century after the Normandy occupation of Sicily that was under Muslim rule. So Professor Maqdisi kind of like found the timeline and traced how the trust came into the common law. So when we say waqf, we're meaning a trust. Now, trust can be revocable and they can be irrevocable. Same thing, a waqf can be living revocable or irrevocable. So, or will trigger and terminate at the happening of an event. So that's why we're talking about the family waqf is a joint family living revocable trust.
Got it. Perfect. Thank you. And yeah, that's a good level set, and just I think a way to clarify maybe some confusion out there, just in terms of jargon terminology. I notice we're bumping up against the the amount of time that we've allotted here today. I do want to maybe ask each of you an open-ended question, sort of broad. Go with it wherever you see fit. And Fatima, we'll start with you. What mistakes do you see on the estate planning front that you wish people wouldn't do, that would save you some headache and heartache, and kind of advice, generally speaking, you might give people to avoid them?
Don't ignore this issue. I think again, it's something that none of us are really looking to spend our free time thinking about an estate plan, but it's much better to do it before there's a reason. And that gives you some time to think about these things rather than in a rush. If suddenly some situation occurs, and again, sometimes it might be you're leaving for Hajj and you need to quickly do it, and people will rush to get something done, or we're getting close to a tax deadline. So before all of those things come up, just think about what are the important documents that you need. Maybe if you need like a more elaborate plan, that's fine. At least make sure you have the basic documents in place, your healthcare directives, your power of attorney, a will. And then again, you can build off of that. But again, make sure you at least have the basics in place.
Perfect. Thank you. And Abid, same question to you.
I second Fatima. Fatima is a financial advisor. She does this for a living to protect people's family and preserve their wealth and fulfill their faith. An estate plan is it's a moral and religious obligation to protect your family, preserve your wealth, and fulfill your faith. You got to think about it. You just don't know when you're going to pass away. You just don't know. It could be on your way to work. You could be traveling. It could be on Hajj. You want your family. I felt such a huge burden off my chest when I created my living irrevocable trust for my family. I was traveling, and I'm like, I had represented people who died in airplane crashes in the beginning of my career. So I'm like, you know what? I'm going to get on a plane. I may die. Then what's going to happen? So I created my trust, and it just was a burden off my chest. And that's what I want everybody to understand. It's about protecting your family. This is why we do it. Protect your family, create your trust or create your will, and you'll feel a sense of obligation and satisfaction that you did something right for your family.
What a great way to end it. Thank you both for such a wonderful discussion, and really can't appreciate you folks for sticking around. The participants who remained on the webinar, thank you for the wonderful questions. And as we conclude today, we want to leave you with some action items which are on your screen now. Please take a moment to look through those, and obviously we want to make ourselves available to you at the conclusion of the webinar. Please feel free to reach out to us. I'm going to give you that contact information in just a moment. But before that, I want you to mark your calendars, because we need to take the opportunity to inform you about our upcoming webinar schedule. If you liked what you saw today, we're going to give you some more in the new year, God willing. So it's going to kick things off in January with our outlook and state of the company report on January 30th. Please be on the lookout for more information on that soon. And I want to thank again our guests today, Fatima and Abid, and special thanks again to everybody for sticking with us, being with us live. If we didn't get to your question or you'd like more information, some of those were pretty specific, please reach out to us. The email hello@azadasset.com. Obviously, Abid's available at Shariawiz.com. Abid, you want to throw an email out there, contact for Shariawiz?
It's my first name, ABED, @Shariawiz.com.
Perfect. And be sure to follow us on social media. The handle for our Facebook and YouTube accounts is @AzadFunds. You can find us on LinkedIn under our full name, Azad Asset Management. We invite you to complete the survey that will load at the conclusion of today's webinar. We do very much value your feedback. We read those, and we appreciate any guidance you may have on future webinars. We take those suggestions very seriously. Thank you again, everybody who joined us today, and have a great evening and weekend.
Yallah, assalamu alaikum, everyone. Take care.
Wa alaikum salam.